Good evening, Section Z. We are in Chapter 11 on zoning, and this evening we're going to take a look at some mechanisms that are used to build some flexibility into the zoning process. The authors point out that Euclidean zoning can create hardships for landowners, that it can promote inefficient land use sometimes, and so they have put escape valves into the typical zoning system so that you can sometimes vary from the zoning ordinance in particular situations. So for instance, if a lot couldn't be used consistent with the zoning ordinance, they might allow a variance so that you can make good use of it. On the other hand, there are some downsides to flexibility in a system of zoning. The authors point out that the power to regulate flexibly can also be the power to favor or disfavor for illegitimate reasons. And so you can imagine situations where the zoning authorities make exceptions to the rules and choose to favor their friends or their relatives or their political supporters, or people who pay bribes, or just people with no legitimate basis for getting relief from the rules. The first mechanism that we're going to discuss is called the variance, and the book has a case that we're going to look at. Here we go. Commons versus Westwood Zoning Board of Adjustment. And so here, the case is in the New Jersey Supreme Court. The plaintiffs filed a request for a variance in front of a zoning board of adjustment, and that variance was denied. Then the plaintiffs went to court asking for a review of the zoning board's actions, and the case went against them in the court, and so now they've appealed that decision up to the state Supreme Court. The zoning restrictions in this case were in a residential neighborhood, and there was a requirement that lots were supposed to be at least 7,500 square feet, and we're supposed to have a minimum frontage of 75 feet. So let me see if I can pull up a diagram to kind of show you what's going on in this case. So here's a diagram to try and show what's going on in this case. We have a requirement that lots are supposed to be 7,500 square feet and supposed to have a frontage of about 75 square feet. But this particular lot had just over 5,000 square feet, and it only had 30 feet of frontage. So it was about 3/7 of the required frontage area and about 2/3 of the size that you were supposed to have for the total lot. And so the plaintiffs can't use their lot consistent with the zoning ordinance. They got into this predicament because they apparently bought the lot after the zoning ordinance was adopted. Their predecessors in title had acquired the lot in 1927. The zoning restrictions at issue were adopted in 1947, and then the plaintiffs bought the lot at that point. And so they are asking the Zoning Board of Adjustment for a variance. They want to build a house on this lot even though it will not satisfy the requirements of the zoning ordinance. So a variance basically is permission to depart from the requirements of the zoning ordinance, and it is sought on the ground that there would be undue hardship if you had to comply with the zoning ordinance, which the court here takes to mean that no effective use can be made of the property in the event that the variance is denied. And so what they've asked for permission to do is to build a kind of a long, skinny 4-bedroom house. And so they're still going to meet the requirements for distance from the lot lines and from the road, but it's going to be a little different looking than most of the houses in the neighborhood, and the lot is going to be smaller total footage and much smaller frontage than most of the houses in the neighborhood. Kind of a hot dog shaped house, I guess, or a bowling alley or something. So the Board of Adjustment denies the variance, and they have two arguments for that. One is that the applicant here didn't demonstrate any evidence of hardship, and the second was that granting the variance would substantially impair the purpose of the zoning ordinance. On appeal, the court decides that there was not enough evidence in the record to support the zoning board's conclusions. The finding that there was no hardship, they think is not supported by the record, because without a variance, this lot would be zoned into inutility. You could not do anything with it. They had made some efforts to try and correct the problem or partially correct it. They had tried to buy 10 extra feet along one side from a neighbor, but had not succeeded in doing that. They had tried to sell their entire lot to one of the neighbors for $7,500, but the neighbors only offered the assessed value of $1,600, so significantly less than it was worth in terms of market value. So the finding that there was no evidence of hardship, the court thinks is not sustained by the record. The other ground for the board's action was that the proposed variance would negatively impact the public good and undermine the zoning plan. Here, the court decided that the zoning board had not adequately explained its conclusion that granting the variance would impair the purpose of the ordinance. The house would be smaller than others in the area, but it would be comparable in value. And so effectively, the court is forcing the Board of Adjustment to make findings that support the conclusion it reaches. The court, in the full opinion, says that that's necessary so that they can review and make sure the Board of Adjustment is doing its job, and to permit effective court review. The Board of Adjustment is not limited just to the options of granting or denying a variance. There is something else that it could do. If you look at the note 1 after the case, the authors point out that you can grant a conditional variance, and this is actually something that the court mentions in the full case, is that you can attach conditions that try to protect neighbors. In the full opinion in this case, the court mentioned the possibility of denying a variance if the neighbors buy the property at its market value. So basically saying that you can build your house unless the neighbors pay you what the land is worth to keep you from doing that. Now, notice this here, that a variance must run with the land. You can't grant a variance to one landowner and say that it doesn't apply to their successors. So variances attached to the property and benefit later owners of that property. What happens if a person, as in this case, buys land knowing that you're unable to use it without a variance? Does that mean that your hardship is kind of self-imposed and a variance should be denied? There's a split of authority on that issue. Some courts say that essentially you would be making the property unsellable, or at least you'd require somebody to apply for a variance before they tried to sell the property. And so they decide that's not a self-imposed hardship that would prevent you from getting a variance. Note 2 after the case, the authors note that the burden of proof is greater if you're asking for a use variance rather than an area variance. And so if you want to build a commercial establishment in a residential neighborhood, it is harder to convince the Board of Adjustment to let you do that than if you want to just build a house in a residential neighborhood in a too small of a lot. The authors say that it's kind of like the difference between the pig in the parlor on the one hand, the use variance, and an oversized sofa in the parlor on the other, the area variance. The second kind of flexibility mechanism that the book discusses is what is called a special exception, or sometimes called a conditional use. Basically, this is different from a variance because a variance is permission to depart from the plan of the zoning ordinance. But a special exception or a conditional use is actually something that is contemplated as at least a possibility under the ordinance. And so they are used in situations where it's not necessarily, the use is not necessarily incompatible with the area, but you want to pay close attention and make sure that you're not going to cause any harmful consequences. And so they give typical examples. They say often, things that use large amounts of land and involve uses that could potentially cause injury to surrounding areas like airports, landfills, and hospitals. Neighbors might be affected by noise or traffic, and so you need to get a special exception or a conditional use permit in order to build one of those under many ordinances, so that the Board of Adjustment can take a close look at your plans and make sure that they are designed to minimize harm to neighbors. The next mechanism that is discussed in the book to put some flexibility into the zoning process is the zoning amendment. So here on page 588, we have the case State versus City of Rochester from Minnesota. This is a situation where a person wasn't seeking a variance and wasn't seeking a special exception. Instead, they were asking to have their land rezoned. They wanted the zoning regulations to be changed so that this particular area would have a different zoning classification. It was currently, or at the time that they applied, it was zoned for single-family residential use. They want it rezoned to high-density residential use so that they can build a 49-unit condominium on the property. And so one issue the court wrestles with is, how do you characterize a zoning issue? And there is case law in different jurisdictions supporting two different ways of looking at a zoning amendment that affects only one parcel of land. Some courts say, well, that is kind of an adjudicative decision, that it's analogous to the decision to grant or deny a variance or a special exception. But others say, well, no, if you're actually changing the zoning ordinance, then it is more akin to a legislative decision. So that characterization issue can matter. It matters whether you view this decision to rezone a particular parcel as legislative in nature or as adjudicative in nature. In our system of government, the people are the sovereigns, and they delegate their authority to legislative bodies. And so the people who are exercising legislative authority are acting as the people's representatives. Therefore, courts tend to be deferential to legislative decisions. They are only reversed if they're inconsistent with applicable constitutional law or the decisions of some higher legislative body. On the other hand, courts are less deferential towards administrative decisions that are viewed as adjudicative in nature. These are more like decisions of a lower court, and they feel more freedom to review and overrule decisions. When we think about an adjudicative decision, we're thinking about something that may be like a trial in some ways, although maybe less formal. You have parties show up and present evidence. They may have other procedural rights, like the right to cross-examine witnesses for the other side. There may be safeguards in place to protect the impartiality of the decision maker. For instance, it may be against the rules in an adjudicative proceeding to have ex parte contact with the judge or decision maker. A legislative body, on the other hand, we think of as having a little bit different kinds of procedures. We imagine a process where there is collective deliberation among a group of decision makers and then some kind of vote at the end. There may or may not be a hearing, but if there's a hearing, the participants generally don't have many procedural rights. And legislators often work closely with representatives of those who are interested in the outcome of a decision. So this issue has been raised in different jurisdictions. And in an Oregon case called Fasano, the court had reviewed a rezoning process and decided that it was a small enough parcel that it should be viewed as kind of quasi-judicial in nature, and therefore the court should be less deferential to the decision. But in this case from Minnesota, the court decides that a zoning amendment is legislative in character. And so over on page 588, they talk about the consequences of that conclusion that it is a legislative act. They say, as a legislative act, a zoning or rezoning classification must be upheld unless opponents prove that the classification is unsupported by any rational basis related to promoting the public health, safety, morals, or general welfare, or that the classification amounts to a taking without compensation. So much more deferential standards of review. Here, the legislative zoning decision satisfied the deferential standard of review. There was a need for more high-density housing in that area. This was a good location for it. It was close to some primary thoroughfares, close to bus lines, near community centers, childcare, central business district, and it was surrounded on two sides by other high-density and institutional uses of property. In the notes after the case, the authors bring up an issue that sometimes arises in zoning matters, the issue of spot zoning, which if you decide something is spot zoning, that's a way of saying it's illegal. You have illegal spot zoning basically when you single out a small parcel of land for special or privileged treatment. It benefits the landowner, but not the public interest, and it doesn't accord with the comprehensive plan for the area. So it's essentially creating a kind of an island, typically of privileged treatment for one parcel of land. In this case, the court faced an argument that this was spot zoning, but they rejected it on the record, finding that there was a justification for the rezoning and that it was consistent with the purposes of the zoning ordinance. So that's it for flexibility in zoning. We will talk next about some ways that zoning has been expanded to accomplish other sorts of purposes than those we saw in the Village of Euclid case.